All right. So welcome everybody. We always with these webinars, we want to bring topics that are important for small business. We've had the good fortune of one of Crown Heights' local business specialty lawyers. There's lawyers that have specialized in different fields, but Ainsworth Gorkin, they specialize in business law. That's what they focus on. That's what they do every day, all the time. And we're honored. This is already the second time that they're doing a webinar with us. They're going to cover a lot of ground, common business legal issues. Okay, when you're running a business, you can meet. There's just common. There's obviously everyone has unique circumstances, and then you'll have to speak, individually to a lawyer. But there's certain common things, which as Levi will say again, this is not. You can't take this information and act on it. This is just general guidelines. You always have to speak directly to a lawyer privately to get an exact socked in, so to say. But we're going to speak generalities. We're going to cover a lot of grounds. We want this to be interactive. So first of all, please unmute yourself. We're going to cover, Levi is going to give you an overview. We're going to cover a bunch of different topics quickly, and usually we do Q&A at the end, but in this case, after each topic, we'll take questions. So without further ado, I'm honored to have all the way from sunny South Florida, Levi Ainsworth is on, and he'll take the lead today. So the floor is yours. Go for it, Levi.
Thank you, Robert Wardy. So also thank you very much for getting ahead of me on the disclaimer and disclosure. Obviously, none of this is supposed to be taken as legal advice, and if you guys do have specific questions, happy to address them. But I've always had a struggle when in such a environment to provide valuable information, because every situation is pretty unique. So it's difficult to give very specific advice or things like that. So the idea here is to really try to talk pretty broadly at different stages of businesses. When you're starting the business is going to be one stage of, what entity to create and things like that. And when you're going to fundraise, when you're starting out your business with employees, you're bringing on investors, employees, dealing with vendor agreements. There's a wide range of things that come up that can be overwhelming at different times. So this is kind of just an outline to address some of these common pitfall and issues that come up for most small businesses.
So actually, what I want to do to take a pulse of people's interests and where they're holding, we're going to do this very quickly. Levi's going to say a topic, and if you could, everyone could open their chat box for a second. For each topic, he's going to say, when he says the topic, type me if it's relevant to you. I want to see which ones are the most relevant. This way, we'll spend more time in the areas that have the most interest. So go for it. Topic number one is?
So the first topic is really just starting out your business. What entity to have, what the difference between like a sole proprietorship, LLCs, corporations, and those initial formal documentation and the importance of getting that organized. That's the first topic.
Okay, so whoever, 1 second, stop. Whoever's interested in that topic, type me. I see one so far. Anyone else? Two. Okay, so we got to 3, 4. Oh, okay, we got 4 votes on that one. Okay, next topic.
The second topic really covers initial operational matters that you're going to run into, such as employment-related issues, intellectual property, and wide range of contracts that you're going to have to deal with, whether vendors, clients, customers, you name it. So, and how to negotiate, approach them, and the importance of such documentation.
Okay. How many people? Write me if this is relevant to you, please. Let's see what we have. 1, 2, 3 votes on this one. Okay. Next topic.
It's going to be on growth and scaling. So this is going to cover more about bringing on investors at seed rounds, as well as whether it's debt, and also looking for expansion, what to be paying attention to, what matters on a compliance level and contract level as you guys grow and move on to different stages of the company.
How many people is that relevant to? Type me if it's relevant to you. 1, 2 votes. 3 votes. Okay, it's pretty equal across all. And okay, and what was the last topic?
The other one was ongoing operations and risk management. So it's mostly talking about litigation risks, how to minimize it, what does litigation mean, or disputes, and what forms can potentially resolve it.
Okay, if that's relevant to you, type me. 1, 2, 3, 4. All right, we're getting 4. And we mentioned valuations already. You said valuations, Levi?
So valuations would be touched upon with bringing on
With
investors.
her. All right, so it looks pretty even across all the topics, pretty much 3 to 4 on each topic. So okay, we'll go through everything. Go for it.
All right, so just a quick introduction with Ainsworth Gorkin. I'm a partner with Shai Gorkin. My area is mostly on the business side, transaction side. So I deal a lot with contracts, startups, operating agreements, vendor agreements, client agreements, a wide range of contracts that come up. And for a couple of clients, act as general outside counsel. So they don't have a need necessarily for someone full time, but we're in touch almost all the time as a variety of issues arise, or not issues, but scaling ability or contract needs and things like that. Shai handles commercial litigation ranging from partnership disputes, real estate related disputes, investor disputes, debt disputes. So it's kind of, those are the areas that we really kind of focus on, and I mean, thankfully we've been able to grow within there. As I already mentioned, there's going to be a couple different stages of this. I don't want this to be one-sided, so at the end of each stage, we'll kind of open up the floor for any questions, and we can kind of go through it a little bit more in detail. So when starting out a business, obviously there's a couple ways you can do it. You can either do it from inception, where you're commencing and creating the business from scratch, in which you'll create the entity, whether that be an LLC, corporation, sole proprietorship, or however way that you may find yourself going down. And then the alternative is just buying an entity, an already existing business, whether you're buying all the assets or buying the equity or shares within the company and taking over the company itself. So there's a couple different ways you could do it, and there's obviously different risks as you go about that. So to kind of just assuming we're starting from scratch, there's 4 general entities that most would be familiar with. There's a sole proprietorship, a limited partnership, S&C corporations, and LLCs, which is limited liability companies. So sole proprietorship, from a legal perspective, doesn't really mean much. It's really from a tax perspective. So you'll usually see this with small businesses, like a side hustle. They're not really off the ground. They don't really want to invest the money, and there's not much of a separation. So they're, let's say, picking up odd end jobs called TaskRabbit or something of the sort. And it doesn't really necessarily make a lot of sense to create this whole separate entity for what could be a small amount at the end of the year. So they'll do a sole proprietorship. From a tax perspective, there's a difference, but from a legal perspective, liability, everything else still stays with the individual. So if you're starting out and you're not expecting it to really go far, that may be an option. But generally speaking, if you're intending to have a business where you're going to have employees and or try to grow as time goes on, it's likely not going to be a great way to start. A limited partnership, you don't see this that often, but you'll see it a lot with more bigger investors. So like real estate investments, sometimes we'll structure like that, and other investments. It's typically you'll have a GP, which is a general partner, and they'll run the company and the partnership and make all the decisions. And then you'll have limited partners or LPs that are essentially just investors. They don't have much of a say, voting rights, or anything like that. And they kind of go from there, but you're really entrusting the general partner. So reputation becomes a big thing there, and prior track records are what give them the viability to kind of go from time to time. So you'll see like also large hedge funds will structure a lot like LPs and GPs and things like that, because the LPs don't really have much of a say, and they're just coming in for the investment purpose. The more commonly known entities that you'll be familiar with are LLCs and corporations. There are some distinct differences. Limited liability companies provide a lot of flexibility, where you can kind of structure any way you want. You can have a member having 50%, but you may have no real voting rights. You could have different profit margins. So you can, let's say, have 50% and only take 30% of the profits. There's a lot of flexibility. Each state has a statute relating to an LLC that's formed there. Almost uniformly speaking, if the statute will maintain, so even if you don't have a operating agreement, you can rely on the statute for how things run. That's usually by a majority. But if you have an operating agreement, that pretty much opens the door to structuring any which way you want. So for example, if you're running an LLC and you hold 10%, you can still ensure that you're the only one to really make the decision. And that could be through being a managing member. That could be through just the way the operating agreement is formed. So this becomes a very, very key document in order for the business to go forward. I'll go into a little bit more as well as, I personally have seen a lot of disputes arise from this, and the important decisions that go into making sure that the time is spent to go through a lot of the details when forming whether an LLC or corporation. Now, on the other side, there's corporations. C corps are usually what is used for publicly traded companies. So for a long time, a lot of companies that were starting and anticipating maybe down the road to have a IPO would start as a C corp, but that's kind of moved away and been a little bit more open. And most companies are starting off as LLCs, as I'm seeing them now, and in general. And S corps are also form of corporation. The difference between the two is taxation. C corp is taxed on two levels. S corp is kind of like a pass-through, similar to an LLC. The downside for corporations is there's a lot more formalities. So the shareholders are not necessarily the officers or the people with authority on the company, whereas LLCs, you can have one and the same, and there's a lot less formalities. So with corporations, you have to have annual meetings, you have to have minutes for the meetings, you have to have an assigned secretary, you have to have assigned proper officers and as such, whereas LLCs give you a lot more flexibility on that. You can have minutes, you can have meetings, you don't need them. There's a lot more ease to go with it. I think it suits a lot more small businesses to have the flexibility. And the issue with that is if you don't maintain the formalities of a corporation, you run the risk of not having the corporate protections. As a result, meaning you're not going to have the legal protection of this is a corporation, and I personally shouldn't have any personal liability as a result. So if they go after the company and they see, the company is expensing all, if someone's living off the company and using it for their car, for tuition, for a bunch of things, they realize the company's just kind of commingling their funds with personal use, they can, what's referred to as pierce the corporate veil and kind of go after the individual behind it. So to maintain that level of corporate function with corporations versus LLCs is a lot more difficult. And personally, I more often than not will see that those formalities are not maintained. Luckily, the issue doesn't come up that much, but in a litigation down the road, that may become a key factor. So as I was referencing before, there are several different documents that you'll need in order to set up the business. So with LLCs, you'll have articles of incorporation and an operating agreement. And with corporations, you'll see a bylaws and shareholder agreement. Bylaws is kind of dictates how the company functions and how the decisions are made. The shareholder agreement is just between the actual shareholders. So it kind of separates, once again, the owners from the operators versus an LLC. You can kind of combine. You can have officers be the owners and vice versa, and doesn't have to create much of a distinction at all. So, and I want to kind of take a couple minutes to highlight the importance of these initial documentation. A lot of the times when people are running into a business, there's a lot of the positive that's going, which is very important. And it's important not to kind of get too bogged down in too much of the detail and too much of the weeds, but at the same time, it's really important to have a clear indication as to what are the roles and responsibilities of each partner. What is the decision-making process? What are the financial obligations? What's the budget? How's the budget made? Who makes all these decisions? And can you sell your equity? Can you not? How do you have to go to the other person or not? And the reason why a lot of these things are important is because it sets the expectations clearly. Let's say there's two partners on the same page day one. So if you understand what that person is supposed to be doing, it's very clearly written in your agreement. If they cease doing it, usually there'll be some sort of path forward. So for example, and I've run into this all the time, where you have 50-50 partners, and no one really discusses this, but what happens 3 years down the line? One of them decides they want to pivot, move into a different industry, or even retire. How do you deal with that? And the answer I almost always get is, what do you suggest? And it's always been funny to me that that's never been thought about, because you're giving up 50% of a company and everyone's just looking at it as, what are we doing today? And I think that's a very important thing to consider of what are the possible outcomes in a year, 3 years, 5 years from now. Now, granted, a lot of businesses don't make it necessarily past year 1, 3, and 5. I think I think 50% of businesses don't really make it past 5 years. So, it may be a wasteful way of thinking, but I think it's a really important one, because if you're on the positive 50%, you can have a business that's worth a lot and not have a lot of protections within the agreement. So it's really important to ensure this. And I would say is almost a substantial majority of disputes between partners is almost always about their roles, responsibilities, what they should be doing, shouldn't be doing, or how decisions are being made. And a lot of this can easily be protected by having a somewhat difficult conversation early on, but I think it's always easiest before anything starts because, I mean, there's less to give up. There's more just about the potential, and it allows for more of a seamless process. And I have personally found it as well. It diminishes the likelihood for a dispute down the line. And if a dispute arises, you can easily deal with it. So, for example, from an investor's standpoint, I've represented some investors in agreements. I ensured an accounting, strong accounting. There had to be anything adjusting the budget needed his vote. There had to be a P&L every quarter. So they always had a very keen eye of what was going on financially. And that gave them a lot more comfort to understand that. And then the working partner, if they walked away, there was a call option. Basically, the investor was able to buy them out for a discounted price because they were giving sweat equity. So there's a lot of ways to kind of balance out, both of their positions, and vice versa. The working partner had a clause in there that if the investor didn't hold up their end of the bargain by funding when and how they needed to, they can bring in another investor and buy them out for a fraction of the price. So it kind of gave them both protections that if the company needed money or if someone wasn't fulfilling what was expected, there was an easy way out, which avoided of like, what do we do now? So a lot of operating agreements, unfortunately, don't really deal necessarily with what happens if things don't go smoothly. And if those things are clearly delineated within the agreement, it kind of provides an easy off-ramp of a dispute and a path forward. Because usually when there is a path forward in these agreements, there's not much to argue on. And I found this to be a very key point, putting aside even legal, just to kind of set all the parties' expectations. Because usually when you're starting the business, you're thinking very much on a granular term. This kind of ensure that everyone's a little bit more grounded and understanding, okay, day to day, what are you doing? How are you doing it? Do we need to hire other people? Wow, we have to hire a team of 5. So then maybe your salary shouldn't be so high, or maybe I shouldn't be giving you so much equity, and allow them to kind of really work through kind of like a business plan for the first 1 to 3 years comprehensively, and that they were on the same page and really kind of help them move forward as opposed to constantly having to go back and forth with negotiations. So that kind of is structures kind of how these businesses are getting started. I kind of want to open the door. I can talk about this particular area, but I don't want to get too along.
Yeah,
we'll take
some quick questions. Raise your hand if you have a question. But we want to move this along, but we'll answer a few quick questions. Anyone has any particular questions on this topic for incorporation and partnership agreement and articles of incorporation? Anyone? Raise your hand if you have a question. No, there's no one raising their hand. So if you want to unmute yourself and ask a question, you could do that now. Otherwise, we're moving on to the next topic. Okay, I guess you did it. You taught it so well. No one has questions. Okay, let's move on.
Not a problem. So the next area I want to concentrate on is kind of when the ball starts rolling, business starts operating, you're going to start running into a whole host of issues. One of them is going to be employment law, and I think this tends to get overlooked quite a bit, surprisingly. I think a lot of people look at the difference between employees and independent contractors as almost insignificant. However, there are strong differences between the two, how they're treated and the like. There's kind of a test of the difference between an independent contractor and an employee. Employees are, provided tasks independently. They have to show up to work every single day. They can't work for other people. Their work and expectations are pretty much fully controlled by the employer. Versus an independent contractor, can have multiple clients and or people that are paying them. They're charging for a specific fee. They're not being controlled on a time basis. They're being controlled more like on a project basis. So if they show up for 2 hours one day, or I'm working on the project, or 6, doesn't make much of a difference. And they have some level of an economic independence versus employees are really kind of showing up and getting paid every time. The problem with this, if these are not properly maintained, the difference is the liabilities are anywhere from, it can trigger an audit with a regulator or IRS or some other governmental agency, You can also be liable for back pay, overtime, etc. Because independent contractors, you're generally not paying overtime, whereas employees, if they're non-exempt, any hour over overtime, which is over 40 hours at the current time, is time and a half. So you'd be subject to that with additional penalties. You may be on the hook for disability payments and workers' compensation issues, as well as tax and other monetary damages and penalties. So ensuring that you are clearly differentiating between the two becomes a very important factor. In addition, whether you have an employee, independent contractor, doesn't really make much of a difference. It's really important to have NDAs in place for a variety of reasons. NDA is a non-disclosure agreement. This is also known as like a confidentiality agreement. It ensures that they're not going to have the ability to just disclose and or take whatever information they find and use it for their own purpose. Now, NDAs don't cover anything and everything within the business. Obviously, it has to be, it can't be public information or things like that. So there is a limit on what it can be used for. But for employment agreements, what could be used is, and I think what's very strong is non-solicits. And that's a non-solicit of other employees and or contractors, but very importantly, clients and or customers. Unfortunately, a lot of small businesses, there's a lot of trust. People will come on, they'll all of a sudden now know customer lists or vendor lists, and they'll decide, you know what, I think I can do this business on my own, go somewhere else and kind of just set up shop and start kind of pulling away some of that business. There's also non-competes, but that's been going back and forth on its enforceability. It's still enforceable at the current time, but there's been a lot of talk about removing the ability to enforce non-competes. It's currently being litigated, and there should be some more clarity in the future. But the non-solicits is really what I believe is most important for a lot of these businesses. The non-competes, people can compete. Your concern is not them competing, it's really taking away your customers, your employees, and your current infrastructure that you have in place. And that you can 100% still use. And I think that's a big missed opportunity when people get started. There's a lot of excitement coming on board, just like with a partner, and it just gets left to the side. And even some companies that are on top of it will have an agreement, will ensure it gets filled out. A lot of times don't actually get it signed. So it's important that day one, when any employee starts, you have some sort of non-solicit in place. And good employment practices would also indicate or dictate that there's some sort of offer letter delineating and outlining what's the expected role, what is their role, what's the hours, what are they getting paid, and it is useful to write that it's at-will employment as opposed to kind of some sort of locked-in period. At-will basically means they could quit whenever they want, and you can kind of fire whenever you want. And also at this point, it's usually any type of bonuses or incentive structures are really important to have in writing, especially when some employers might give some equity or promise of equity or things like that. It's really important to have these things in writing to avoid downstream potential litigation and or liability. It ensures organizational clarity, but also if they claim now that they're owed XYZ, if you don't have anything in writing or anything like that, it becomes very hard to dispute one way or the other, versus if you have a clear agreement, they can claim whatever they want. This is what they signed up for, and it avoids any downstream issues. Along with employment comes a whole slew of laws that are also on the books at the moment. There's paid and unpaid leave. So there's the FMLA, which is a federal law for employers that have over 50 employees. There's the New York paid family leave, which is as long as you have one employee, you're subject to it. And in New York, you have to provide at least 40 hours of sick leave every year, and that has to be registered and clear. If that's a full-time employee after a certain period of time. The FMLA provides, if you have over the 50 employees, that you maintain the person's role for at least 12 weeks, and you're willing to give them a period of time off, whether it's for having a child, sick family member, etc. Whereas in New York, paid family leave is also up to 12 weeks, but they're also entitled to some sort of pay. But that doesn't necessarily come from the employer. It comes from the employee payroll deductions. Part of like one of your insurances, almost anyone that uses payroll should have that in place as well. And a big issue that comes up especially a lot in New York is hiring and firing issues. I believe New York rates as a top 3 state for employee initiated lawsuits. So it's really important to kind of have ducks in a row. So for example, if an employee is working by you and they are not satisfying their job requirements, though it be uncomfortable, it's really important to document and notify them so that you're kind of creating a clear, documented reason for their firing or for their issues. Um, it's usually uncomfortable because when the employee sees it, they get uncomfortable. It forces a conversation. But if you end up, firing them down the line, they claim, retaliation or discrimination. You can show back and say, well, there's these 6, 7, 8 reasons as to why something, what led to the termination. Really, really does help employers. It's something that unfortunately is heavily overlooked and not done quite as often as I would like to see, but really does help down the line. And I believe there was a recent study showing that I think the average employee lawsuit costs employers about $100,000, even if they can win, because just hiring the attorney, going through the litigation, if it goes through trial, it can end up being a little bit more, and it takes time, effort, energy, and takes away the concentration on the business to now you're just dealing with issues as opposed to the growth of the business. But again, there are insurances that can kind of protect against these things. So insurance is always a good option. So you just kind of sleep a little bit more steady at night. Moving on to, I guess.
One second. So before we jump to IP, since we just talked about a lot about employment, anyone have particular questions? We'll take a minute here to answer. Anyone has a specific question that's related to this topic, please raise your hand and we'll give you a chance to ask Levi. If this topic is relevant to you and you want to ask a specific question, now's your chance. Okay, looks like we move on to the next topic. Okay, Levi, rolling along.
By the way, I don't bite if anyone's concerned. Also, we're on Zoom, so I can't actually physically do anything. With intellectual property, there's some pretty stunning statistics when it comes to intellectual property. I think it's only 13% of small businesses actually register their IP, and there's numerous different ways to do it, mostly through patents and copyrights. And trademarks are the ways to really cover yourself. Trade secrets are what most businesses are going to have, which is like their confidential information, such as their financial plans, their customer information, their formulas, whether it's mathematical, whether it's even anything else with their business. But it's a lot of how your business functions that would fall into trade secrets. Patents are really more for inventions that then gets filed and that maintains a certain period of time. You can extend those out as well, even once it gets up to the deadline or when it expires. There are ways you can expand that. Copyrights really protect against more expressive style works, and trademarks are more what you'll see almost every day with like logos, and Kellogg's and even different major brands will trademark those as well. Anyone have any major questions when it kind of comes to intellectual property?
Go ahead, raise your hand if you have a question.
I will say is one thing, interesting thing to mark, and I'll probably touch upon this when we go to the next section, is when companies have their intellectual property properly trademark, copyrighted, or protected in any way, it definitely incentivizes or makes investors a lot more comfortable, whether it's investor or potential buyer of the business, because it leaves less room for someone else to step in, and they know that that asset is a truly protected asset. So it does become a pretty valuable thing down the line. Maybe not right when you do it, but it's very valuable when you're looking for funding and or to sell the business.
By the way, I just want to emphasize what you're saying. A lot of people, when they start their business, we actually did one of our first webinars years and years ago. One of the presenters said, when you build a business, you have to make a decision. Is this going to be you building this to be your lifestyle business? It's your business forever, or are you building it to sell it? And a lot of people don't ever think about that. A lot of people, that's their love and their passion, and they jump in. But really, a lot of businesses end up being sold, and they can only be sold, like Levi's saying now, if there's assets and values And it's good to know about these things and think about these things, because the more valuable your business, you make your business, the more people will pay for it. You know, if you invest in these types of things, if you think that that's a pathway, it's just important to have in mind.
Yeah,
Sorry,
and I
just
think that also,
Okay, go ahead. Who is that?
sorry, it's Julian. Sorry about that.
Yes, you have a question?
Yeah, just a quick question. So we see a lot like for example, like Uber and Lyft, same business model. Could someone just not steal the name Uber and like their colors and stuff? Like how did Lyft kind of do that? And secondly, even now I go to the kosher grocery stores and I see like very similar cereals as like the main, like secular brands, just different names. So even though there's a lot of emphasis on protecting it, but like what could they really like protect? Is it just like the name and like the colors,
so
or
it
like
would
a
be the
tech
name, the
company? Yeah,
logo.
yeah, the name, the logo.
When you're talking about trademarks, that's really what they're protecting. Uber, you can't really protect a business model. So Lyft coming in
Yeah,
after is really just second to it. So Uber already created the name. I mean, Uber was substantially bigger, and it took Lyft quite a while to catch up. But once they did, they were there. That's really protecting their name, their logos, those kind of things.
Okay, I see Schneer raising his hand. Go for it, Schneer.
Hey, quick question. So I work in product design and development, and a lot of the times our products will get patented down the line after, the product is developed, the form that it's going to stay in. We also are working on some of our own products in-house that we would, like to sell to other companies. I guess my question here is, what type of patent should we do on that? If we should patent it, are companies interested to see that there's protection on it to some extent? Or is it for ourselves to patent it? Maybe even just provisional so that we can present it to customers? Like, how careful do we have to be with that? Do you have any advice
So
on
in
that?
general, I think whenever you commence a conversation with any potential buyer, it's always really imperative to have an NDA in place. And that will be the initial protection to be using. With regards to the patents itself, it is very specific. You're talking about a very detailed conversation that would need to be had. What differentiates it? What makes this an independent and new invention that is not there before? You also have to double check and see what else has been patented. And it can take a little bit of time for the patent to actually be granted. This is something that's like, I don't want to get too into detail here because it really depends on so many variables and how you're doing it, where you're getting the information. But I will say in an industry like yours, especially like marketing, where you're creating so much artworks and logos and brands and things like that, your contracts are going to be imperative of who actually owns that IP. So a lot of times what ends up happening is you may, a lot of these companies will say, no problem, I'm happy to give away the IP, but you may actually want to keep that IP and then license it out. There's a lot of different ways to help protect it so that you can use it for marketing purposes yourself. We've worked and made these brands, or you can kind of stem off of the already created intellectual property and create new ones. Versus if you have no ownership over it, technically speaking, you can't even use it to kind of build on for others. So with coding, that becomes also quite an important factor that should be considered.
Perfect. Thank you.
No problem. I know I didn't answer
Alright.
the question directly, but I don't think I'd be able to on a call like
Yeah,
this.
it's loaded. We could follow up on that. Thanks.
No problem. So, and I think one of the key points I really want to spend a little bit of time on here, obviously not too much, is contracts. I feel that I believe that most people view contract as technicality and just want to get past it as quickly and easily as possible. And it really depends on which side you're on, what the purpose and of the agreements are, and you mean what the intentions are getting out of that relationship, whether you're buying a product, whether you're buying services, whether it's an employee, whoever it is. I think it's really important to understand before going into any contract, what are you expecting? What's the other party expecting? And then if you have a clear understanding and idea of that, it becomes a lot easier to then move forward through it. There's obviously also a lot of variables. There may be a relationship that you don't want to be too aggressive on the negotiations, but there's going to always be a couple points that are very impactful and important for the business to ensure that they have properly protected. So I've seen, letters of intent, you can call them MOUs, you can say ton of different versions of what you want to call it, or term sheet, being used in a wide range of areas. Surprisingly, I actually personally use it for employment agreements with like executive employment agreements. It's been incredibly useful to kind of negotiate a lot of the high level business terms that when you actually get to the contract, there's not much to negotiate anymore. It's just like technicalities. It's actually massively helped for both the negotiations and the legal drafting. So the overall time gets diminished substantially. And also the parties then are really just dealing with the negotiations head on from the get-go, clarify what's needed or not, and then we can move on to the next stage. It's useful for real estate, buying, selling businesses, financial transactions, let's say lending, borrowing, investors, things of that nature. And it really is a very useful tool, to be used. Now, LOIs, MOUs, term sheets, everything else inherently are non-binding. You can't really bind someone to an agreement to go into another agreement. There are certain terms within LOIs and MOUs that you can make binding, such as expenses, exclusivity. So for example, if you're looking to buy a business or sell your business, one of the parties can ensure that they're exclusive to be the buyer and or seller for a specific thing. If they let go outside and start offering their business to someone else, you can say you're in breach of that agreement. So there are some aspects you can make binding, but you mean the core idea of what an MOU or LOI is that it wouldn't actually be binding. Now, there's a lot of, depending on the nature of the transaction, once again, it's really dependent on what becomes important. But almost always, these are pretty considerable items, such as exclusivity. So if, let's say, you have an independent contractor, do you want them working for some of your competitors or not, whether direct or indirect? Whether you're a vendor or going to a vendor, like, is that the only vendor you're going to be using? Are you tying yourself up to using other vendors and potentially better pricing, better sourcing, better timing, etc.? So it's really important to understand if you're able to kind of leverage that and or use some level of exclusivity. Payment terms is always an important aspect. So for example, if you're the one providing the services or the product, ensuring that payments are being done timely. And a way to get around that is any late payments have some sort of penalty involved in it on an ongoing basis. So 1% a month gets charged, or 1.5%. And it always just allows a little bit more leverage to say, okay, I'll waive the default fees if you pay right away. So there's these small things in the contract. Each one individually don't necessarily cause major changes, but collectively can really help through a contract. If there's a default, how are you going to deal with that remedy? So if, let's say, they're late on shipping you something, then what? If there's no clear remedy, now you're basically looking for damages. So you have to prove how that damaged you. Them being late to send some sort of good, how that damaged you, versus if you deal within the contract, okay, if you guys are later than 30 days, we get a 20% discount, 30% discount. It becomes a lot easier to manage. And then also it avoids the fight. So you can maintain that relationship, get the discount that was already negotiated, and move on to hopefully a healthy relationship thereafter, if that's the desire. Insurance is also a thing that's constantly overlooked. So if you're dealing with a service provider, for example, and they mess something up, you want to ensure that they have insurance, because if you go after them, they're only as good as what they have. So if you're, let's say, dealing with a company, excuse me, and they make a mistake and they're 100% negligent, but if they have no assets, no money, you're essentially chasing something not to get paid. And what gets lost upon a lot of people in a litigation is you're not looking to win litigation, you're looking to collect on it. So eventually at the end of litigation, you get what is a judgment. And in order to collect on it, there has to be some sort of assets. So when you're kind of working with other people and they're not massive companies and they may not have the wherewithal or the financial ability to cover some of their issues, you may want to force them into having insurances. So if God forbid something does go wrong, you don't have to deal with them. You go straight to their insurance, make the claim, and move on. It saves you attorney fees, and it actually ensures you'll actually get something at the end of the day. In here as well, IP considerations. So for example, as I touched on before, if you're using a marketing company, you'll want to have it in there that you own that IP versus you're just getting it licensed. Important clause always is choice of law and venue. So that refers to what law is the contract subject to. For example, most customers, clients would be within New York, and venue would be is, do you go to court? Do you go to arbitration? Do you go to Besden? Do you go somewhere else? And also there's other considerations there of like service of process. You could do via certified mail. There's a lot of small things within each of these clauses that can substantially help a company as they go through it. Already touched on this one, that at the end of the day, your protections are really who's on the other side. So ensuring that you know who you're going to business with, and that they can either satisfy or fulfill what they're claiming, whether it's services or product, and that there's proper protections in place, such as insurance, or that they have enough assets or otherwise that if something does go wrong, they have the ability to come and actually pay for any downside. Another way of so the next point is kind of more within the context of like M&A, which is buying, selling businesses, or even products, to ensure that, let's say you're selling your products, you want to see that they're actually for real. You may require some sort of deposit. It's a really good way to weed out people that are kind of just feeling it out and ensure that they're really going to go through with it because they have something to actually lose. The next kind of subtopic is more about online business, e-commerce, like websites and things like that. But does anyone have any questions relating to like the contracts, terms, things like that, negotiate and the negotiations?
Yeah, raise your hand if you don't mind. Pull it, and then we'll call on you if you have a question on this topic. Not much. You know what, Levi, I'm just thinking here because it's already someone, Schneider, you just raise your hand again?
Yeah, just a quick question on
Yeah.
equity-based contracts. Is there something you could speak to quickly on that?
When you say equity-based contracts, what are you specifically referring to? You mean like partners?
Yes, partners are doing work and then at a lower rate, and then some sort of contract with equity on sale. And that's
So what you're
also
saying is like
topic.
having either employee or independent contractor working, providing a discounted price, plus they would get equity at a certain point.
A little more towards the client side. If we're doing a deal with lower price on design work, but on contingency that once the product launches, we become some sort of equity partner.
Sure, those tend to be complicated contracts because it's kind of like an option or a vesting interest. It would be on the company. It really depends, again, also on their operating agreement. So what gives them the authority, what type of equity they have and or shares, when that's going to be actually, the trigger would be important with that product. It would also, you'd want to cover a lot of things. Again, this is probably a longer conversation. I can probably talk to you a little bit more in detail after this call, but
yeah,
it would.
Sure. I like that. Is that called an equity contract?
Not really.
Okay.
It's a service agreement with some equity as consideration or payment, but it gets a little bit more complicated than that. It really depends on the company, their formation, their foundational documents such as an operating agreement or shareholder agreement, and also you'd want to very clearly have what the trigger is and what happens if they sell the product before it actually goes live and someone else has it. There's going to be a lot of ways you want to kind of cover that. The trigger is going to be the key point.
Thank you.
No problem. So another thing that's been kind of coming up a little bit more is with websites for online businesses, having like privacy policies. Some companies will just kind of pace what they'll see from bigger companies, which may or may not be applicable. Sometimes it could just work fine, and other times it won't. But it's really important depending on what you're doing with the information you're getting. So if you're getting personal information such as names, emails, IP address, things like that, you're going to have to kind of have a good privacy policy and proper protections in place. And if you're disclosing that to third parties, so having APIs, technically speaking, could be disclosing it to third parties because they'll have access to certain information. It's really important to ensure that those are being properly compliant. You have an actual privacy policy in place, which would be displayed on the website. Most businesses, as you'll see over here, 75% of most small online businesses don't actually have a proper privacy policy or are just simply not compliant whatsoever. So these are very important factors. There's the GDPR, which came out a couple of years ago for Europe, which is pretty aggressive, and California has a a very similar structure and law. So if you have customers in California, even though let's say you're in New York or somewhere else, it's still applicable if you're getting that customer's information from there. Another key factor with websites would be the terms of use, in terms of conditions and advertising. So a lot of times when you're selling goods online, you'll have your return policy on there. You could have, what liabilities you have, venues, so arbitration or otherwise. It's really important to have that on there so it kind of covers you substantially. Any bigger company you'll see have a pretty detailed terms of use that cover a wide range of things. At the very least, it's important to have something on there that covers limits your liability, deals with choice of law, venue, and what your return policy is and things like that, so that it really avoids potential issues and or disputes with your customers, vendors, whoever that may be. And also advertising. It's really important to advertise honestly and realistically. So you can't really advertise something that's not there. Otherwise, you can run into a variety of different issues. But obviously, highlighting the FTC could be an issue, and a bunch of other agencies that overdo it. So depending on what products or services you're selling, it might be a consumer related, and different agencies will have the purview over there. Also, funnily enough, sponsored content is starting to become a bigger thing, especially with social media. The FTC requires it's got to be clear this is a sponsored item or paid for. Otherwise, again, you can run into a variety of different issues. This is going to be kind of going through some of the investors and things like that. So what kind of struck out at me was 70% of early stage startups face legal risk from not having proper documentation with their investors, and therefore would run into SEC issues or others. I could say I've seen this personally. A company brought in an investor, was actually a syndicator. They had documentation, but it just wasn't great. They ended up having a dispute with the investor, and it just didn't make sense to fight it out. And we advised our client to just kind of settle it out and paid a bunch of money, even though the investor took the risk, because their documentation just simply was not good enough. And in a litigation, it would have cost them attorney's fees and then have a huge risk as to whether or not they'd have to pay out more. So ensuring that prior to bringing on investors, you're really ensuring that your ducks are in a row is a very important aspect. Otherwise, you have no leverage and you're kind of at the will of your investor. There's a couple items, vehicles or investment vehicles I'm going to kind of run through: convertible notes, safes, preferred stock, and common stock. Convertible notes and safes are relatively similar. This is kind of giving money. It's kind of like a mix of a debt and equity combined. So convertible notes are essentially, you're giving a principal amount that's going to incur interest, and there's a maturity date. And if there's a conversion event or something like that prior, which is, let's say, selling the business, bringing in other investors, things like that, that note can turn into equity at predetermined discounts or conditions as agreed upon by the parties. So you might say, is like, if there's a new investor that comes in before the maturity date, I'll get a 20% discount. So which means my valuation will be 20% worth 20% more. So valuations are not that important because you're kind of kicking the can down the road to when you get more of a VC style where they'll put like an actual specific valuation. At this point, it's just saying is I'll get a discount from that next investor. Key terms here are the maturity date and interest. So the problem with convertible notes are that it hurts the investors because there's a maturity date, and if that maturity date comes before another investor walks in, now you owe a bunch of money, both the principal and the interest. And now that investor has the leverage to say, you know what, I'm willing to continue rolling with this, but I want more equity or a bigger discount or whatever it is. They have a lot more leverage at that point. And usually with startups, cash is always tight until you bring in that bigger investor. So convertible notes are useful, but it does give a lot of leverage to the investor if the money's not going to come in pretty quickly or before the maturity date. Whereas safes on the other side of that coin do not have interest associated with it and don't have maturity date. So they're kind of locked in. This is a lot more friendly towards investors. So it's basically just sits there until the new investor comes in. And similar to convertible notes, you don't actually have to have a dollar figure associated with the business or a cap table or things like that. You have to have a cap table, but you don't have to have evaluations. because it's kind of kicking the can down the road as to when that next round happens. What's really being negotiated is what discount or upside do we have for being an early on investor. And this gives the investors, the founders, a lot more room, a lot less pressure because there's no maturity date and there's no interest being accrued as well. So kind of they give $1 million, it stays at that $1 million. The question is what type of equity. Now, even though convertible notes do generally convert into equity, or most people, but the principal and interest are still due. So it's technically a debt going in, but almost everyone views them as equity. The question is when you're going to convert, and you mean if there's a convertible event prior to the maturity date, is who's going to have more leverage. You can also do preferred stock and common stock is another way, but these end up being a lot more complicated, and therefore takes a lot more time to negotiate because there's a lot more variables and they're kind of coming in as equity holders day one versus they're getting the equity at the next conversion stage or next round of funding. Preferred stock kind of gives, and the difference between preferred and common, preferred means you're kind of splitting up the stockholders, and the preferred have a preference. So that preference might be they get paid out their principal first, they may get additional interest. They're just treated differently and they're given a little bit more of a higher priority across the board. But again, these tend to be a lot more complicated and therefore take time. That's generally why convertible notes and safes are used so much more often. There's a lot less to negotiate because there are a lot less variables. You're really kind of relying on the next round of funding, whereas common stock is really just you're on an even playing field with all the other investors. So if there's no preferred stock, everyone's kind of treated the same, and it really depends on how. Again, this comes back to the operating agreement or shareholders agreement, how everyone's being treated, what are the voting rights you have, and everything else really are subject to that. But everyone's on the same playing field, so they're not quite as complicated as preferred stockholders, but there's a lot to also be negotiated. You can also choose to bring in debt, and there's a couple different versions of that debt. You can do. I'm going to run through this a little quick because I know we're kind of a little bit low on time. There's term loans, and there's also lines of credit. Term loans are a little bit more aggressive because you have to pay it all back by the maturity date. There's usually more risk for the lender, so they tend to be more expensive. Whereas lines of credit is the lenders just agreeing that you can borrow and reborrow the same money, pay it back. So they end up being a little cheaper because the lender is not out the full line of credit at any given time. However, anytime you do draw from the line of credit, usually you'll have to provide disclosures and financials in order to show to the lender that the company is functioning, it's going, and it's not deteriorating, and therefore it's not going to be a bigger risk to continue borrowing from it. Both of them can be either simple or complicated. It really depends on the lender, how big the loan is, and what the status is going on. And in each of those circumstances, you can have a secured or unsecured creditor or lender. Secure just means that they'll have priorities over others. Over particular assets, it might be first position. So if there's a default, they could take that asset. Obviously, there's different ways that goes about, but whether it's membership interest, you can pledge your membership interest. So if God forbid you default, they can kind of come in and take the equity from the company or specific assets as detailed within the agreement. Versus unsecured is they can't go after any specific asset. The only real way they'll collect is essentially filing a lawsuit, similar to like what you would imagine a credit card being. They can't really go after any specific asset. They need to kind of just go to court, get some sort of judgment, and try to collect through that. Robbie, Wardy, are we wrapping up? Because I know it's 3 o'clock, or do you have a couple more minutes?
It is 3. We do have a couple of. I'd like to cover everything. But did you mention, by the way, valuation? You covered that?
So valuations, I did cover a little bit with convertible notes and safes. In the early stages, valuations are discussed a lot, but are not integral. It becomes a lot more important once you start doing bigger rounds, dealing with VCs or Series A rounds or things like that. The way convertible and safe notes really work is you're kind of kicking that can down the road and getting a discount on whatever the next investor gets. You'll get a discount. So instead of having to pay $100,000 for 3%, you're able to come in at 2% because you were earlier.
Got it. Okay. All right, so
and then another big thing.
Yeah.
I'll wrap up this section as well as just really compliance and litigation risk. I'll touch upon quite quickly. Compliance is really important because every state could be different. You may have licensing requirements, registration requirements. You may even in some contracts, depending on the state, need more disclosures. So as I was saying before, with the privacy policy, if you have one, you would want to specifically reference, like if you're from California, these statutes apply or whatever it is. And there's disclosures and things like that. So it's really important as your company grows outside of where it starts, whether it's New York or others, to really be on top of what's needed. What contract changes do you need to do? What website changes do you need to do? Do you need to add disclosures on your products, services, goods, things like that? And that becomes very important, because eventually, if that doesn't get done, you run into an issue. I mean, there could be tens of thousands of dollars and legal fees and things like that with any regulatory body, between fines and other things. After this, kind of the next stage was really talking about litigation and the risks that are associated with it and how to kind of manage it. But this last part talks more about kind of managing the risk, dispute resolution, and liability. So I know we touched upon all of these a little bit, but regulatory compliance is really an important aspect. This covers anything from HR to licensing requirements. So, for example, I know in some states, LLCs have to file an annual report. If they don't file it, they can actually just dissolve the entity, and all of a sudden you're operating under a company that's actually not incorporated. So it can create a whole host of issues. So, for example, Florida is a state like that. So it's really important to manage all of your aspects of your business properly, and always be making sure. Now, it doesn't always have to be a lawyer. There are third-party servicing companies, such as accountants and or companies that just help you with corporate filings. So it doesn't always have to be a heavy cost or have to be a lawyer. Dispute resolution is a really key point. There's different aspects of it. There is litigation, arbitration, and mediation. All of them are super useful depending on the circumstance and the need. And insurance and insurance is a very key fact that just doesn't get considered for a lot of small businesses. You can get liability insurance, workers' comp, property insurance, AR insurance, which I find a lot of small businesses don't necessarily know. So you can kind of have your
AR stands
customers'
for
account receivable. So if let's say you have a customer or client, they don't pay their outstanding balance, you can get them insured. But it's a process having to do before you actually you have to get those customers approved by the insurance, and then they'll, I think, cover up to like 70%, 80%. So all dispute resolution. As I was saying before, planning, which usually comes down to the contract, really helps a lot, where you clearly outline the responsibilities of each party dealing with it, timing triggers, what happens in the event that those things are not met correctly or properly, and also clearly displaying what the services are. I've had a customer where their services was assisting clients with college applications, and it was a very vague term of service that it became very difficult to clearly state that my client fulfilled its obligation, versus if they said, hey, we're going to provide XYZ, and they did provide a lot of work and go into it, but because the contract didn't clearly state what the services were, it became almost ambiguous, and therefore it was a very hard position to be in when a dispute arose due to the fee that was outstanding. You can also limit your liability when it comes to services or goods to a strong degree. Obviously, you can't do it completely, but you can to the contract, depending on what the circumstances are. Also, assigning choice of law and or venue becomes important. So the difference, I'll walk through a little bit here, of litigation, arbitration, and mediation. Litigation is when you go before a judge. The judge has the authority over the case and will make a decision. What the judge is doing is not really making a determination of the facts. They have to just make a determination of the law, and that's it. The facts are really being presented by each party, and the judge really just determines what the law says based on those facts. Most of the time, you're never going to go to trial. 95% of cases really settle before. I would actually assume that number is probably a little bit higher, to be honest with you. And the decision by the judge is binding. Now, you can appeal those decisions at any given point. So you go to a higher court for that and go all the way up to the Supreme Court of the United States. But obviously, if you don't appeal it, it stays binding. Arbitration is a little different. It's not in front of a court. And it's also not public record. So court is public record. So if there's a litigation ongoing, you can see what's happening. You can see all the filed documentation. everything's kind of public record, whereas arbitration is more private. It doesn't have a public forum, and you can pick and choose what those are. So, for example, Bezdin is an arbitration. You can decide anywhere from 1 to 3 to 5 arbitrators on being on a panel. The most common ones for non-Jewish is JAMS and AAA, and they kind of also have similar structure to a court, where it's you present the evidence and everything else. However, the evidence is not as strict as it would be in courts. There's a lot more room to maneuver, and the benefit tends to be with arbitration. Usually, it's quicker and should be cheaper as a result. However, that's not always the case. There's been some arbitrations that have taken quite a while, but they were quite complicated. The downside is it's not as predictable. You're dealing with 3 people, or 1 to 3 arbitrators. You're not dealing with precedent, whereas a judge has to determine just the law, and they can always be appealed. Arbitrators, it's a really, really difficult to appeal. You have to prove like a really huge miscarriage of a justice or something quite egregious happening for you to have the ability to appeal on arbitration, and the decision is binding by that arbitrator. Once you get a decision by the arbitrator, you can get it confirmed by a court and then get some sort of judgment if necessary. Mediation is non-binding. It's usually done by one person normally. I haven't really seen it done more than that. There's no specific procedures. There's nothing really implemented. It's more of a concept where both parties will come, speak to the mediator, and have a third party try to walk through some of the issues and find some sort of bridge to bridge the gap between the parties and avoid a bigger dispute, because obviously whether you go to arbitration or court, there's always the unknown. Depends who you get, what the facts are, and it's never 100% on any case that you're doing. Similar to what I was telling Yossi, effective legal counsel is always a collaborative effort, and therefore it's always important that you're talking to the attorney and you're providing as much information to the attorney so that they can kind of tailor the needs and also give the advice best that suits those specific scenarios. I've spoken to some clients where like they would tell me after the fact, I don't want to tell you this particular fact because I thought it would hurt me. At the end of the day, is we couldn't protect them from it, and as a result, it probably hurt him more from not telling us something, and we only found out later. Thankfully, it hasn't happened in any situation where it was too late, but it definitely helps being very upfront and ensuring that you're a part of the process, and you also are understanding what's happening and how it's happening, as well as also ensuring that your lawyer is explaining what's going on. And I think the more collaborative it is, it tends to be better for both sides. Back to questions if there are any.
All right. Good. I'm happy we covered everything, because this way we'll cut out the Q&A and we'll post this as people can reference it. So thank you, everybody. Thank you very much, Levi. This was excellent. And for those that wanted to follow up with you privately, you said that you could talk to them. How do you want that to be? You want them to reach out to you directly, or you want them to come to me? Or how do you want to do that?
Happy if you want me to post my email address here, or you can provide my email address. Happy to kind of communicate
Yeah,
by
go ahead,
email and schedule a call.
Post it, and yeah, if anyone wants to speak to Levi privately, he's offering just a free consult. You could reach out. Levi will post his email address on the chat. There it is, Levi at ainsworthgorkin.com. Thank you all for coming. Thank you, Levi, for this presentation. We wish you all continued Hatzlacha, and we'll see you again next month on the next webinar. Take care.
Thank you very much for having me. Have a great day.
Take care. Thank you, Levi.